The second analogy I want to come to, I think will more readily be taken as a more serious one, and that's the analogy of originalism to biblical literalism. And part of the thing that, and it does seem to me to make much more sense to want to interpret the text of the Bible according to its original intent if you think that the original intent is the intent of God. And it is certainly the case that people take biblical literalism much more seriously, whether, they are, whichever way they take it, they're much more interested in getting it right, in doing the kind of work, whatever in their faith tradition it's seen to be, to see what original intent means. But I also think that that sort of originalism is part of the Protestant tradition of textual interpretation, which led me to another series of questions that I asked of folks and couldn't really get an answer to, although I would be interested in one. I'm also, among my scholarly interests is comparativism, including but not limited to comparative constitutionalism. And I'm curious that as far as I can tell, certainly originalism is not a universal method of interpreting constitutions, and to the extent I'm aware of it, it only comes into play in countries that have some Protestant or similar kinds of connection. If you look at, for example, the French Civil Code, it's not the Constitution, but it's almost contemporaneous with the original Constitution, and you look at what the interpreters of the French Civil Code say about how it is to be interpreted, at the time, in the 18th century, they specifically repudiate originalism and describe something very much like living constitutionalism. Of course, it needs to be updated and reinterpreted from time to time. And I'm sort of wondering whether, Catholic countries, for example, are at all given to original interpretation or are more likely to do more updating. Which leads me back, in a sense, to the question of originalism and women, and the question of popular sovereignty. Now, I've been spending at least as much time on the canon law as I have on the Constitution lately. And I want to put the issue of the relationship between women, popular sovereignty, and the Constitution in that context. And again, my objection from the perspective of women in the Constitution is partly procedural, but more importantly substantive. The substantive rules that were in place and were reaffirmed by the framers of both the original Constitution and the post-Civil War amendments with respect to women are rules I don't want to live with. And, Fallon is worried about a Constitution that will find Social Security and paper money unconstitutional. I'm much more worried about a Constitution that will find coverture and the elimination of women from public life constitutional. The maxim I'm going to use to put this in some context may be familiar to some of you. It's a maxim that started in canon law and expanded into political theory as early as the Middle Ages. I give it to you in Latin, including its Latin tag, and then translate it and explicate it. It goes by the name quod omnis tangit, and that's a shorthand for the Latin sentence quod omnis tangit per omnium disputare et approbare debet. What touches all must be debated and decided by all. And I most recently had the occasion to invoke this maxim in the context of sex and gender in comments I was asked to write on Rowan Williams, the Archbishop of Canterbury's discussion of the potential schism in the Anglican Church concerning issues of homosexuality, but also issues about things like the ordination of women as bishops. And he invoked this maxim, which, as I said, is a maxim of canon law, by saying that what affects the communion of all should be decided by all, and therefore we have to move slowly with respect to change. We have to discuss and debate it. Well, given the historical exclusion of women from decision-making in the church, it seems, and the historic exclusion of women from decision-making in the Republic, to use a maxim like that as a brake on change, this is the conservative part of it, does leave out those people who were not able to be part of the original process of popular sovereignty. Are women part of omnes? Were they part of omnes in any meaningful sense in the framing of the original Constitution, in the framing of the canon law? And women's objection, or objection on behalf of women to this, has a very, very long history. There's actually a tale in Boccaccio's Decameron, Day 6, in which a woman named Madame Philippa is taken in adultery, and she's a great lawyer for herself. She goes in and says, this law that you're trying to convict me of, this law concerning adultery, is one in which no woman had a role in making. She basically cites quod omnis tangit, and therefore it's a very unjust law, and you can't convict me with respect to it. And she wins. And I want to commend to you Madama Philippa's view as you consider whether originalism makes sense in general, but particularly makes sense from the perspective of women, their rights and liberties.